on our office today. If you would like to ask any questions, feel free to type in the chat and I will get to them as I am able. So we'll just go ahead and begin. Well, there we go. As you are probably aware, the Office of Public Guardian was initiated by LB 920, and it was identified that the current practice of volunteers were inadequate or not willing or qualified to serve in some of our vulnerable adults, and it was established to provide services when no private individual is available and to serve as the needs of the ward. It was introduced by Senator Colby Kowash, and it was passed 44-0. So it was as a result of some malfeasance by an individual out in Scottsbluff, and the Public Guardianship Act had been introduced 2 different times, and then with the report from the auditor and the introduction of LB 920, it was passed in 2014. The Public Guardianship Act creates the Office of Public Guardian, and we are one of only 4 entities in the country that is under the Supreme Court. So most of the other public guardians across the country are either under the executive branch or are their own private agency within the executive branch. But we are one of 4 that is, excuse me, under the judicial branch. The court administrator appoints the public guardian, and according to the current statute, also allows for 12 associate public guardians with an average of 40 protected persons or wards to each associate public guardian. We also have the appointment of the Advisory Council, who is appointed by the court administrator. Our responsibilities are not only to provide direct service to individuals who have no one to serve as guardian and conservator, but we also are to promote public awareness of guardians and conservators and report yearly to both the legislature and the Supreme Court. The duties are to act as the guardianship or conservator's last resort, to safeguard the rights of individuals by supporting the least restrictive manner, to model the highest standards of practice for guardians and conservators to improve performance of all guardians and conservators in the state, to develop a uniform system of reporting and collecting statistical data, to act as a resource to guardians and conservators for information and support, and to enhance guardian and conservator success. We also are to maintain the training program that's offered for newly appointed guardians and conservators that are required to take within 90 days of their appointment. And finally, to recruit members of the public and family to serve as guardians or conservators and make reasonable efforts to locate a successor guardian or conservator. That's required within 6 months of our appointment. Currently, there is myself, the director, and the public guardian. I also have a deputy director, Marla Fisher-Limke. We have an education and outreach coordinator, Linda Kalhoff, a finance manager, 2 support staff, and 12 associate public guardians. When we first began to try to implement the Public Guardianship Act, and understood we had 12 associate public guardians, but there was not any real data in regards to where is the need in Nebraska for public guardianships and conservatorships. So the way that we tried to work out our service areas was to look at what are the population of individuals under guardianship and conservator across the state of Nebraska. And there are roughly 10,000 people within the state who are served by a guardian or conservator. And we broke out by population to try to identify, also taking into consideration the travel needs of our associate public guardians. So we have one in Scottsbluff, one in the Panhandle out of Scottsbluff, one in North Platte, one in Kearney, one in Hastings that share actually Hall County. We have one in northeast Nebraska, it's at Norfolk, and we have two that share Lancaster County, one who has Lancaster County and then Gage, and one who has Lancaster County and then Seward, Saline, and Jefferson. We also have an individual who serves at a Papillion that is in the southeast area. We have two full-time associate public guardians in Douglas County, and then we have two other individuals who serve part-time in Douglas County and then up to Sioux City, or one who serves over to David City. As I indicated, the public guardian is overseen by an advisory council, and their representation is a county judge, 4 attorneys, a social worker, an individual who works in mental health, an aging expert, a developmental disabilities expert, and 2 at-large members. They have served they were appointed last January and have served since our first meeting in February. The Act requires them to meet at least 4 times per year, but this group has actually met every single month and has been very active in their support of implementing the Office of Public Guardian. Most of people know us because of the court appointments of specific acting as a public guardian and conservator for vulnerable adults. But also the Public Guardianship Act requires us to do a number of things other than provide direct guardianship and conservatorship. If you take a look at the graphic in front of you, the top right quadrant of the circle identifies that we do provide direct service, that we are identified under the statute having 12 associate public guardians across Nebraska, which with the average of 40 ends up with the potential of serving 480 vulnerable adults. In order to try and manage that we are supposed to be the last resort, least restrictive, provide only necessary services, we also have begun a court visitor program, which I'll discuss in more detail as we go along. The court visitor program has actually been in statute since the 80s, and it identifies that when necessary there would be an individual between the time of the petition filing to the hearing to provide information back to the court in regards to the potentially incapacitated person. And according to, under the probate statute, they are to have a background in law, nursing, social work, mental health, gerontology, intellectual disabilities, developmental disabilities, drug abuse, or alcoholism, and then provide their specialized information to the court. We have identified and will be utilizing court visitors for our appointment process that I'll discuss further. And the other part of the Public Guardianship Act is to provide education, support, and information to all private guardians in the state. And then starting January 1st of 2016, we'll also provide all direct education for newly appointed guardians and conservators. And finally, as indicated by the Public Guardianship Act, within 6 months of being appointed, we need to report back to the administrator of the court that we have tried to find a successor guardian or conservator for ourselves. The implementation also requires that we provide the highest standard of practice and model that within the guardianship and conservator process. And what we have taken a look at as far as our agency standards, our practice, our ethics, our policies is modeled under the National Guardianship Association. And they have specific standards that we have followed in regards to our ethics, our operating standards, our personnel standards, how our certification of our program staff, the fiscal standards that we follow, and the program service standards, and finally quality improvement and grievance procedures. So all of the areas in which we've developed policies and procedures are in compliance with the National Guardianship Association. Additionally, in order to try to maximize and leverage our resources to the greatest extent possible and serve the individuals under our care, we have entered into a contract with Enrollment Management System, also known as EMS. And EMS is a system that provides software case management, and it's able to retain all personal information on wards and estates. So it provides information on a cloud so that 24/7 our associate public guardians can access all the case information about our wards and protected persons, both their medical history, their court history, their financial processes, all of which is under the EMS system. It really is a very powerful case management system, and we've also provided additional development costs that have allowed our EMS system to be able to directly import and export from the bank that oversees our finances for our wards and protected persons. So accordingly, you can pay bills out of the system, you can track all finances, and you additionally can we've paid for development so that all of that information can be downloaded directly into the forms. For example, the annual forms, the inventory forms, all of those things we've developed the Nebraska-specific forms to be able to be downloaded out of the EMS system. We'll be piloting that system over the next year, and because that system is also available usually at a rate about $10 per person per month for private and family guardians and conservators, and we thought that it might be something that would be of assistance to individuals who would want to utilize the system, both in regards to being able to manage the finances, but also then to help alleviate some of the difficulties that the reporting requirements of Nebraska people have indicated over the last few years. And this system might be something that would be able to provide additional support to private guardians and conservators. Our financial protocols, as I indicated, are under the National Guardianship Association oversight. We have decided to centralize all of our finances into an organizational collective account, which will take care of the 480 protected persons through our Office of Public Guardian. It's in compliance with Social Security and VA and all government and financial protocols. Again, as I indicated, it works with our EMS system and our bank to electronically import and export finance information. Also, it allows us to separate out the financial control. So our associate public guardians have only view access to the finances. They have no access to protected persons' finances. All of the finances are directed from our business manager, who oversees expenditures and the protected person's expenses. And then the associate public guardians are the oversight for the business manager, because each month then they reconcile what should have been spent out of the individual protected person's finances, and then reporting back out of the collective account what actually was spent. Additionally, in order to provide assistance to the funds that are held and able to be provided to our wards and protected persons. We have entered into a contract with ReliaCard. It's like a gift card. It can be repeatedly refunded each month, and so it will be held by the ward or protected person, and so the funding is directly entered into the ReliaCard, and they can utilize that for their personal needs allowance. It also allows for centralization of that funding, and therefore no funding is handled by our associate public guardians. Also under the Public Guardianship Act, there's a requirement for data and reporting requirements, and we hope to be able to utilize our software to be able to provide kind of aggregate reports in regards to what types of guardianships and conservators are there in Nebraska, how many are full guardianships versus temporary, how much time and does each case take, what are some of the characteristics of individuals under the public guardianship system. So we hope to be able to provide good data reporting through both our EMS system and the oversight of the ReliaCard and the bank. The court rules and procedures under the Act, the Supreme Court, upon recommendation by the public guardian in consultation with the Advisory Council, was to promulgate rules to carry out the Act. And the rules in regards to kind of the parameters in which the Office of Public Guardian can take cases are that, number one, that they provide only necessary services when no one else is suitable or available, when someone is unwilling, unable, or inappropriate to serve as a guardian or conservator, when the present guardian and conservator does not provide protection or abuses or neglects the individual, where there are alternatives to full guardianship, and it's required to use the least intrusive means and possible in regards to the care and the guardianship of the individuals. The court enters under the Public Guardianship Act. The court may order the appointment of the public guardian only after notice that it's been determined that the appointment is necessary, that it will not result in the public guardian having more appointments than permitted, and upon reaching the maximum, public guardian is not to accept any more appointments and to notify the state court administrator that we've reached that. The determination of necessary also may require that the court ascertain whether there's any alternatives to the public guardian and that it be least restrictive in regards to protection protocol. All of those are under statute in regards to the Public Guardianship Act. So one of the first challenges that we had was to try and determine how do you actually show that you are doing model practice, that you are the last result as the public guardian, that you are utilizing least restrictive means, that it's only under the determination of necessary, and that you have the appropriate reports and data. Well, we took a look at different states. As I indicated, we are the 50th of 50 states to enact the public guardianship. So we have a lot of models to take a look at. And we took a look at a number of states and jurisdictions who use a court visitor or a limited guardian ad litem as an independent investigator. And we took a look at those different states and identified some of the programs and processes that are utilized. And the Model Practice Code under the National Probate Code, Standard 3.34, calls for the use of court visitors. Nebraska statute also allows for a guardian ad litem or a visitor for additional information on the person, as I indicated. Also, to take a look at last resort. A visitor allows for independent investigation to whether any other potential guardian or conservator are available. to identify what's necessary. The visitor will provide a process to gain information for the court on the determination of necessary which the court may be required to make, and to be able to ascertain whether there's any other alternatives to public guardianships. A court visitor also would be able to provide a standard report process for concrete data coming out of that overview and the visitor report process. Quantifiable means to be able to provide compliance data and structure to the Office of Public Guardians utilization and waiting list processes if we get full and have reached capacity. So as we took a look at the visitor statutes, our own, and also how it's used across the country, it was identified that the court visitor serves as the eyes and ears of probate courts, making an independent assessment of the need for guardianships or conservatorships. So we began the Office of Public Guardian Volunteer Court Visitor Program. The statute allows for payment under the counties for visitors, but we were looking at the ramifications of requiring that anytime the Office of Public Guardian is identified or nominated as a potential guardian or conservator, that we use the current statute to require that the court visitor or guardian ad litem provide an independent assessment of the issues required under the Public Guardianship Act. And so we thought that, as in other states that have volunteer programs, we would take a look at being able to provide a core of volunteers who went through training, who understood the screening process, who would use a unified report in order to reach the goals that we had for the court visitor program. Our education and outreach coordinator and our associate public guardians facilitate the volunteer court visitor program. They have collaborated with community providers, stakeholders, and advocates of adults with incapacity, whether that be cognitive or mental health or developmental disabilities and substance abuse, and met with them to talk and to identify potential volunteers for the court visitor program, and also to gain information back as associate public guardians in regards to what resources are available not only for their individual guardians, wards and protected persons that the public guardian will oversee, but also as they serve as kind of a hub of connection for private guardians and conservators who are looking for resources to serve their protected persons and wards. That's taken place in each of the service areas as the Office of Public Guardian identified potential guardians and conservators. They took a look at a standard court visitor report. We identified forms to maximize the standardization of data collection. We have independent information available through the process, the ability to query for reports, protocols for compliance with the statute and the OPG appointment as outlined in the Public Guardianship Act. We believe that it also provides for equitable, fair resource utilization for appointments and waiting lists and enhances the information to the court regarding the case and the person. The court currently, it's required that the court maintain a current list of persons trained in or having demonstrated expertise in the areas that we outlined, and in this way we hope to provide a group of volunteers to the courts around the state who can serve as a court visitor. Some of the individuals that we have identified that would potentially be those who would be served by the public guardian are individuals who have dementia, those who have severe pervasive mental illness, intellectual disabilities, traumatic brain injury and stroke, alcoholism and substance abuse, and then also the times where people have reversible or temporary conditions but can't at the time that they have the need within, perhaps in a hospital, to have not be able to make their medical decisions. We took a look at volunteer visitor programs across the country. Many court visitors actually do 3 different things within their jurisdictions. Much like Nebraska, they're identified as an independent investigative and screening process during the time between the petition is filed and when the hearing occurs. But other states also allow for court visitors to be identified when there's concerns that the guardian conservator that's currently serving is not doing their job. Once the court finds that out, they can appoint an independent court visitor to go out and provide information back to the court in regards to what are the issues for those who are being served. And a third way in which court visitors are used across the country are as auditors. They are volunteers who assist the courts in auditing of financial reports. Nebraska only has specific in regards to the court visitor for the independent investigation, but other states do, as I indicated, utilize them for more of investigatory after the fact and for financial auditing. So what kind of information do they provide the court? And really the court visitor and the volunteer court visitor program, as we've identified it, with requiring them to be appointed prior to a time where the public guardianship actually is identified as a potential nominee, is to take information that's out there and provide it as a conduit to the court. They really, for example, in regards to the requirements, don't provide independent investigation as far as mental status. They don't do the review or the testing. They provide information about that to the court. So when the Office of Public Guardian decided to take a look at providing a volunteer court visitor program, we took a look at recruiting volunteers, processing the application, developing and providing initial online and live training opportunities, developing the screening tool and report reform required by the court rules, and developing an active volunteer court visitor registry for all of the county courts. So we have actually taken that on and have at this time right about 22 court visitors who are volunteering across the state, and we have provided that review of them. We recruited volunteers beginning last December, and through the process have had, as I indicated, the Associate Public Guardians meet in the 12 service areas. I think at this point we are looking at having made 600 different contacts throughout the state of Nebraska over the last 6 months in regards to the volunteer court visitor program. We also have processed applications, which involve, we've developed a court visitor job description, an application tool, an interview process, background checks, and online training, so that the court visitor will conduct a screening according to statute that provides information about the person's ability to make decisions and to take care of him or herself, so that we can make that determination about whether or not it is necessary services, least restrictive, last resort, and there is no other alternative but the public guardian. So the first one of the main things the court visitor does is to interview the alleged incapacitated person and those individuals who are seeking guardianship or the petitioner. They also talk with different providers and any other agencies or medical issues that might have information. We've developed a screening tool to gather that information about the potentially incapacitated person, and it follows specifically with the Nebraska Variety statute dealing with why a court visitor would be identified. And in current statute, there are roughly 9 areas that a court visitor provides information back to the court: their mental status, the selection of their abode, their ability to arrange medical care, their ability to protect their own personal effects, their giving necessary consents, arranging appropriate services and training and education, their daily functional ability, applying for benefits and instituting procedures or entering into contracts, and receiving money and property and applying such to expenses. The one that we added, in addition to those identified under statute, is the consistency of the choices with values and patterns and preferences of the individual when they were their best self. And this is one of the issues that's identified as best practices in regards to the NGA. We have developed also for the training of the court visitor a web-based tool that will provide online education, and there are 15 modules for those who take the court visitor and limited guardianship ad litem, guardian ad litem training, and it's listed there: introduction to guardianship, guardianship authority, surrogate decision making, conditions of the potentially incapacitated person's ward, living arrangements, common problems, abuse, neglect, exploitation, interviewing, communication, community resources, and then of course providing information on the medical terms, as well as the specific use of the screening tool and the report form. We also have, besides the 15 modules of online education, we have 6-hour face-to-face instruction. Usually it's 2 different times of 3 hours each for being able to utilize the screening tool and develop the skills required in reporting the guardian ad litem report form, which is required of all visitors and guardian ad litems. If the public guardian is appointed, then it's mandatory that this report form be utilized. It's not mandatory that an individual go through the training, but in order to provide options for attorneys and also for potential guardian ad litems, we are providing the online modules and the face-to-face components to be able to give CLEs. So if an attorney takes the online for 5 hours, they'll receive 5 hours of online plus the 6 hours in class, and that's 11 hours of total for CLEs. The cost for that program, the screening, in order to have the training, in order to be certified from the Office of Public Guardian for the screening tool and report form, is $175. But for those who are willing to volunteer for the Office of Public Guardian and to be nominated as a case, then we will waive the $150 of the fee for an individual, an attorney who agrees to serve on one case for volunteer court visitor, and they will still receive the 11 hours of CLE. So if you're looking at a way as the year begins to provide just important service, to get excellent training, and also to provide get some CLEs, we would invite you to contact our office and go through the training. So, and then we do provide to the county courts the list of names who have gone through our training and who are qualified and available as a volunteer court visitor. Court visitors are appointed after the petition, and part of their screening process is to take a look at whether or not there are less restrictive alternatives to the guardianship process. And since most of you are involved with the healthcare section, I won't go and belabor this, but there are other ways that people can be protected other than guardianships and conservatory in regards to protecting the person or protecting the property. Surrogate decision-making that's available are advance directive, representative payee, protective payee, a VA fiduciary, power of attorney, durable power of attorney, and then conservatorship. There's also limited guardianship, with or without conservatorship, and of course there's full guardianship and conservatorship. Our challenge is always to try to identify, in regards to our surrogate decision making, that we provide substitute decision making for those individuals who we take care of. And substitute decision making is when you substitute the person's best self, when they were their best self, their desires, wants, and needs. When you're serving as their guardian or conservator, you make those decisions that would represent their desires and needs. When you don't know what their desires and needs are, then of course you go to the best interest standards, which is supported surrogate decision making in Nebraska. Across the country and across the world, though, there is the beginning of the utilization of what's identified as supportive decision making, and trying to identify that you support the individual's decision making capacities at whatever continuum they are in their life. And if you think of it, it's kind of liken it to currently I have adult children, and they certainly are adults and make their own decisions, but recently when one of my sons wanted to buy a house and build a house, they came and talked with his dad and myself about that decision, and we provided support and insight and different questions. We didn't control the decision, but we provided a supportive decision process for them. And what some of the UN charters identified in regards to supportive decision making is to identify, rather than have this you're either incapacitated or capacitated, kind of turning the light switch on and off, that supportive decision making is more of a way in which you can utilize at any level. So even though someone is incapacitated, they still can make certain decisions, and it's just identifying what are those decisions that they can make and support those decisions. So, but surrogate decision making, one of the things that I've been asked is, what is it that we can do across the state in regards to what would be helpful? And I've identified that honestly, if we can maximize the use of advanced directives within our state, then it will help not only for the medical decisions that come later in life, but also it helps those individuals who are trying to make those decisions according to the substitute judgment standard to be able to identify what is it that the person would have wanted at the time that they now do not have the capacity to make those decisions for themselves. Of course, representative payees is also an alternative to provide financial support without a guardianship or conservator. Protective payees under the Department of Health and Human Services is a way in which the Nebraska Department of Health and Human Services can an individual can receive the public assistance payments on behalf of the other person. Also, that's in the ADC program, the state disability program, and the state supplemental program. The VA fiduciary is a surrogate decision making, the powers of attorney, and the durable powers of attorney, before you get to a conservator who is making the decisions based upon the management of the estate and property or business affairs. And then, of course, the person the court looks at first has a priority status, but it's only after there's no one else available that the public guardian program would step in. Also, guardianship, of course, is for protection of the ward and the person. Nebraska law allows for and favors the appointment of limited guardians, and this is a guardian who looks after a limited number of the person's personal needs based upon what their capacity is and based upon what they can handle, rather than a full guardianship. What we found in a lot of our discussions across the state is that although it's required under statute that the consideration for a limited guardian be considered first, that there are very few limited guardianships being currently utilized in the state of Nebraska. Now that could be that it's the rationale for that is because we've done a really good job of utilizing alternatives in the surrogate decision-making process, and only to the point where we really absolutely need guardianships and conservatorships have we gotten to limited, so therefore we need full. Or the other thing that may be actually at work here is that there is very limited information in regards to providing to the court, except for asking for full guardianship, and it's been the practice of to request full guardianship. Part of that may actually be because it's an expensive process, and you know, families are looking towards trying to take care of their loved ones, and even though they perhaps could be a limited guardianship, that they ask for full, and then within the family provide the appropriate level of decision making as the person, and then expand that as the person becomes more and more incapacitated. But as we've identified, limited guardianship is an issue in regards to our statute that's required to be considered prior to the appointment of a full guardian. Some of the care that a guardian, you are certainly familiar with this, is in regards to where they live, their medical care, their personal effects, any consents, training, education, or rehabilitative services, their benefits, actions against anyone whose duty it was to support the person, contractual agreements, money and tangible property, and so it's a rather extensive utilization of the law to take over a guardianship of another individual. And I talk about that in regards to having kind of the two faces of guardianship. One is that it's necessary, so important for protection and appropriate finances, protection of the finances, protection of the person, and just such a necessary need. But on the other side of the face of guardianship, it actually takes a tremendous amount of civil rights from an individual, and is identified in some circles as actually unpersoning the person. They became kind of a non-person in regards to their legal rights and responsibilities. Again, the guardianship, they'll take a look at the priority status in order to make the determination. So how does that work in regards to the public guardian nomination process? Well, as I've indicated, one of the things that has been, probably there's two issues that have been kind of a disappointment to people that we've talked with. One is that the public guardian does not file any petitions. And while I understand that that is certainly a concern and a challenge as in regards to people who have incapacity, I just do share with people that it's not, as far as it is a part of the National Guardianship Association ethics and standards and best practices. And the rationale behind that is that you really do not want the person who is filing the petition, who is a state entity, to identify that the person is potentially incapacitated, and then provides the evidence to support that, and then becomes the person who is appointed conveniently to be the guardian and conservator over that person, and then controls all as the guardian and conservator. That potential for abuse is especially a problem when that is a state entity acting in all of those roles. So the Office of Public Guardian does not file petitions with the court. The other thing that people are disappointed in is that we are not the kind of the Inspector General of the guardianships and conservatorships, that if there are individuals who are concerned about the job that a guardian or conservator is doing, they certainly can contact us and we can provide them support and information in regards to how to file an affidavit with the court to voice their concerns. But people have been disappointed that we are not directly have jurisdiction over coming in and providing that information, but that is not a part of our current duties under the Public Guardianship Act. So the petitioner files the petition with the court and then notifies the public guardian that a nomination has occurred. We will then file an acknowledgement of that nomination and provide information on whether or not we actually have capacity to take a case at that point. If there is no caseload capacity, then we have good cause to be released from the process, and the court would file an order denying the appointment of the guardian. But if they would like to be on a waiting list, then the court can ask that the individual be placed on the waiting list and also appoint a court visitor or guardian ad litem to go ahead and provide the screening, so that when the time is that we might have an opening, that the screening process on whether or not that is a individual who we should be serving has already been identified and completed. If we do have caseload, then pending the hearing, then the court will appoint a visitor, and that individual will begin to provide the screening and the information. The court visitor then will interview the potential incapacitated person and submit a confidential court visitor or guardian ad litem report back to the court. And at that point, file a notice of availability of the report to the petitioner, the Office of Public Guardian, the guardian ad litem if there is one appointed, and the potentially incapacitated person and that person's attorney if there is one. And then we will, as the Office of Public Guardian, file whether or not we have capacity at the time where the hearing takes place, because we will not be saving spots during this process. If there's no caseload capacity, then again we would have the order denying and they would be placed on the waiting list, because the court visitor program has already been processed for that individual. If we do have caseload capacity, then we'll review the report of the visitor and make a determination of whether anything in the report would indicate that there is someone else who could serve and therefore we are not last resort, or potentially if there's information that a full guardianship would not be necessary and maybe a less restrictive options are available, and that would be, if we do find that, then we may file an objection to the appointment. At the hearing then, if everything goes according to the statute and rules, then the court provides the review of all of the things required under the Office of Public Guardian Act and makes the finding that there was proper notice, that the petitioner has acted in good faith and due diligence to identify a guardian or conservator, that the appointment of public guardian is necessary and does not exceed the caseload limitation, that the visitor or guardian ad litem report is providing supporting evidence that no person is available for appointment as guardian or conservator, that all options available to support the individual in the least restrictive manner has been explored, and that the guardian is last resort and there's no alternative other than to appoint the guardian, the Office of Public Guardian, and then we would be appointed in the case. After providing being identified as the public guardian, then one of our associate public guardians will be designated specifically for the individual who will be cared for. Besides the identification of the public guardian, then we also, as I've indicated, have responsibility to private guardianships in education. Previously, the University of Nebraska Extension has been providing education to private guardians and conservators who are appointed throughout the state, and Volunteers Assisting Seniors have done that in Douglas County. But with the Office of Public Guardian, we wanted to be able to provide an ongoing support and information to all private guardians and conservators, and felt that being able to have our 12 associate public guardians provide that initial education would also allow them to be able to have ongoing relationship with private guardians in their service area, and would be able to provide the support that might be necessary for private guardians and conservators. The Office of Public Guardian will provide the private guardianship classes beginning January 1st. The schedule for those training classes across the state can be found at http://ne.gov/go/guardian-education. And as I indicated, the Associate Public Guardians will be providing monthly education around their service areas, and it is a 3-hour live class. People can register online or by phone. The fee is $35 per person, and they can make electronic payment if they do so online, or if they register by phone, then after the registration they can mail in their payment to the Office of Public Guardian Education at our Lincoln office. And registration and payment is required 1 week prior to the class date. We also are providing services to limited English-Proficient attendees. We have Spanish interpretations schedule available for 2016 across the state. I think there's 24 different classes that will provide support to having Spanish interpreters in the class. And you can see the schedule by going to nebraska.gov/go/guardian education. Other languages other than Spanish, we can also try and provide interpretation, but you'll need to contact the Office of Public Guardian, and it requires 45 days of notice to explore the options and logistics and provide the information that will be covered in the court to the interpreter and get that scheduled for someone who is other than Spanish. But please feel free to have clients contact us to try and work that out. As I indicated, we are to provide information to all private guardians, support to all guardians and conservators. We are to recruit successor guardians and conservators, and we are to promote the awareness of guardians and conservators, the responsibility attached, and the need for volunteers to serve as private guardians and conservators. And our basic website is ne.gov/go/public-guardian. If you have any questions in regards to communication regarding the nomination process, that information is there. Our Deputy Director, Marla Fisher-Lemke, is the person who's responsible, and as I indicated, all of the court filings are all centralized, so everything will be e-filed to our office, and we will in Lincoln, and then we will be managing a centralized process for e-filing. If you want more information about Guardian Education Program, that information then is also on the web. So that completes my information that I have provided to you. If you have any questions, I'd be glad to answer them. Simply enter them in the chat. And if not, that is totally okay. You can always call us or follow up. Send me an email or give us a call, and I'd be glad to provide additional information. So I appreciate your interest, and I especially would offer and ask that if you have any concerns or questions or suggestions, we are just beginning to pilot our program within the last month, so we're taking kind of I think we took 2 awards or protected persons and an emergency for each of our associate public guardians 1 month, and we'll do it for another month, and then January we'll start with taking 5 cases per associate public guardian. So we're serving roughly 25 people currently across the state of Nebraska, and it's been a challenge, but people have been very patient and supportive as we are trying to work around our software system that isn't quite up to total ability to export and import finances yet. So we're doing some workarounds on that area. So, but feel free if you have any suggestions to contact our office, because we really value your expertise and your information and the kind of the paradigm from which you in the your section work. So with that, I'll hope you have a great Christmas and get some time off, and thank you so much for your time. Goodbye.